Okay, this is a webinar on advanced asset protection. This is a follow-up or advanced class after most of you have taken or have heard my sort of introductory liability and protection courses. If you haven't seen those courses, that's okay. We're going to briefly review some stuff and so that you won't be totally lost. But we are going to go much beyond that and talk in a lot of detail tonight. And those webinars are also available on my website. So you can always go back and look at the basic liability and protection classes if you need some of the more basic information. Those are available on the website. Okay, so advanced asset protection. Need to figure out how to, there we go. Just a little bit about me. For those who don't know me, because I do have a number of people listening tonight who aren't current clients. I've been an attorney since 1995. That's 18 years. I am much older than I look. I've created over 350 business entities for clients over the years, worked with over 500 clients in various industries. The majority of my clients are in real estate. However, that's just kind of a specialty, but I do have clients that are small business owners in all kinds of walks of life. I've been a personal real estate investor since 2000. When I did my first flip project, actually it was a flip. I don't know if I've told some of you the story, but I meant to flip it and I didn't know what I was doing and I had to turn it into a rental to hold for a while or else I wouldn't have made any money. But that's how we learn, right? I'm a real estate investor. I've done flips, I've done rentals, I've done wholesaling, and hard money loans. I was a licensed real estate agent for 8 years. I am a title and escrow officer. Many of you probably are not aware that I can do your closings, and it's great to have a closing officer who really understands real estate investment. We do a lot of crazy transactions. We use trusts, funky kinds of loans like fractionalized notes and deeds, and a number of other things that some title companies kind of get stuck on. But if you close with me, you know that your closing agent knows exactly what you're doing and your closing will go much more smoothly. I've been an entrepreneur. I've started many businesses, also a small business consultant, educator. I taught at Utah Valley University and Alpine School District. I speak at a lot of numerous associations and RIAs. I'm a published author, three novels, and I'm on my fourth, and a coach and athlete. So that's about me. What does my office do? Entity formation and asset protection, corporate consulting, business and real estate transactional documents, fiduciary services like on your trusts, title and escrow, it should be on there, it's not, title and escrow services, live education and free webinars, you know all about that. Okay, thanks for attending today's seminar. We hope you find it interesting and informative. This is the legalese, and you've all heard it before. What you're about to learn is based on the opinions and experiences of the presenters. That would be me. We strive to provide you with the most up-to-date information and resources, but also hope you understand that every situation and every person presents different factors to consider before making a determination of the best way to proceed. This presentation is for informative purposes only and not meant for personal, financial, accounting, or legal advice. You assume any and all risk of the information or ideas in this seminar. What that really means is, before you actually do anything, call me and we will talk about it and we will devise a plan specifically for you. Okay, so these are general principles we're going to talk about tonight. First, in asset protection, here are some things that I really like to emphasize because there's especially as real estate investors, you go to a lot of seminars and workshops and hear lots of presenters, and I've been doing it for now almost 15 years. And I remember the first seminar that I went to, I think it was a Rich Dad seminar, and someone, got up on the stage. It was the lawyer with this silver briefcase, and it was this bulletproof asset protection package, and it was thousands of dollars. The truth is, there's nothing that is bulletproof. I mean, that's not an accurate statement. They always qualify that with, oh, as long as you maintain it correctly and obey the laws and stuff like that. So there's nothing that's bulletproof. The laws are designed to actually make you honor your obligations and pay your debts. I mean, that's kind of what our laws are designed to do. They're not designed to let you escape liability. In fact, they're quite profoundly written to force you to take responsibility for contractual obligations or your debts or damages that you may cause. Now, that said, there are ways to protect things legally, and those are things we're going to talk about tonight. Different kinds of liabilities require different solutions. And so this is not a one size fits all kind of package. This is very much tailor made. I'm going to give you about a dozen different arrangements tonight. Tax planning, estate planning, corporate maintenance, and asset protection can all be at odds. You'll see that, you'll understand that a little bit more by the end of the broadcast tonight. But sometimes what is best for taxes may not be the best for asset protection. What may be great or better for qualifying for a loan, for that matter, may not be the best for asset protection. If you want to control your estate when you die through estate planning documents like a family trust, which is a great thing to do, but that may not be the best thing for asset protection. So sometimes they're at odds, and it's a balancing act of what your goals are and what is important to you. Is asset protection important? Is taxes more important? Or are you thinking more about estate planning? And that's a priority. So again, that's what I talk about with my clients, and we design packages and plans specifically for them. The more protection you want, the more complicated / expensive your life becomes. That's just kind of a truism. If it were easy, then everybody would do it, and that's just not the case. So you'll see tonight, from very, very simple to very, very complicated structures. The maintenance of your structure is just as important as the structure itself. In fact, it's probably more important. You can spend as much money as you want on legal work. I'm happy to take your money, but really, after we set up the documents, maintaining it correctly, making sure you jump through the right hoops, you do the proper accounting, you sign documents in the proper way. I've had clients come to me with very complicated asset protection structures they paid a lot of money for, and then after I ask them maybe 3 questions, I can find out that they are not maintaining it appropriately because the money's not going through the right hoops. And so in that case, if they were ever sued, they would have no liability protection and they just wasted their money. So I try and help my clients maintain their structures as well as set them up. LLCs and partnerships are used for protection, and we're going to talk about those tonight. The land trust, which we'll touch on tonight, is used for privacy. It does not provide any protection, but privacy can help you in your protection. And family trusts are used for estate planning. Again, they generally do not provide any protection. Some do, some are great, but most do not. And they are designed to allocate assets upon your death. So that's its purpose, is to allocate assets, not to protect them. A simple combination of protection, privacy, insurance is generally the best option for most people. All of these tools can be used in different combinations. So we're just going to put a whole lot of tools in your toolbox, and you will learn or discuss with me how to best utilize them. Okay, this is going to be just a brief review of liability. I teach an hour webinar just on this, and we're going to cover this in about 5 or 10 minutes. But because we need to use these terms for the more advanced stuff. There is a difference between personal liability and professional liability. Personal liability is something that you do as an individual in your individual capacity. The classic example of this is if you're driving in your car and you are in a car accident, and you injure somebody else. That injured person is going to sue you as an individual because you were driving the car, you're the one that caused the damage, so you are the one that's responsible. That is called personal liability. You can also find personal liability on debt obligations if you did a personal guarantee on a loan, like a mortgage. All mortgages are given in your personal name, and so you personally are responsible for that debt. Professional liability is something that happens in the course of a business that you are running. A classic example is the slip and fall in your business. Your business might be a rental property, or it might be a store, a grocery store. In law school, we studied the banana peel slip and fall case. It's a very famous one from decades ago. That somebody literally walked into a grocery store and slipped on a banana peel, and it was injured. Or if your tenants fall down the stairs because the railing wasn't affixed to the wall properly, or the floor subflooring was loose and they pushed through it, or something on the deck, etc. Because that's the business that you run, this is professional liability because somebody's being injured in your within your business, and therefore it is your business that is liable for those damages. So again, personal liability attaches to you as an individual. Professional liability attaches to your business. Because all of you, because you're good students of mine, all have entities formed to do your real estate business. Because if you don't have an entity set up for your real estate business, then you have no professional liability because you have no profession. You're not in a business. And so all of your tenants and slips and falls and anything you do in your real estate business will actually also be personal liability. So that is why we set up entities in the first place, is to separate personal from professional, and there are some good reasons for that, which you're going to see tonight. So going on with personal and professional liability, there are two kinds of protection in these two kinds of liability. The first, we're going to start on the right side, which is the corporate veil protection. The corporate veil is this protection that is offered to all businesses that are properly formed and maintained. So LLCs, corporations, S Corp, C Corps, etc. This corporate veil protection, what it does is it protects the owners of the business from debts and damages and lawsuits of the business. So let's give an example. You've got a rental property and your tenants slip and fall, they break their neck, so they're paralyzed, and they sue you for $2 million. Who are they going to sue? They're going to sue the owner of the property, which is your entity. So they're suing your LLC, and that corporate veil protects your other personal assets from that professional liability. So it creates this veil or this barrier in between your business, what you do is in your business, and everything else in your personal life. So your personal home, your personal savings accounts, your cars, other assets, so other LLCs that you might own, those are all protected. The liability stays stuck within that LLC. Okay, so that's a great thing, and that is why we always set up entities to run a business in, is that we want that corporate veil protection. Now, the other protection we get is called charging order protection. Most of you may not have heard of this. This actually protects the assets that are within the business, such as your actual rental property, from liabilities that arise outside of the business. So from your personal liability. So let's do this kind of the same example in reverse. Let's say that you are driving in your car and you're in a car accident because you were drinking and driving, which you should never do, and you were speeding, which you should never do, and you hit a bus full of kids. So you've got a $10 million lawsuit. So they're going to sue you personally, and they're going to try and get anything that you as a person owns. Now, this will include your personal home, your personal savings account, and all of the businesses that you own. And if you have an LLC with a rental property in it, they're going to try and go after that business asset, that rental property that's inside that LLC. If you get charging order protection, and we're going to talk about how you get that tonight, if you get that charging order protection, then the court cannot force you to remove that asset out of that LLC. So it protects that asset from the liability that you run personally. And we'll cover this kind of, a little bit more as we go on, but we'll kind of let it sit there now, because if you look at the screen, the charging order protection protects assets within your LLC from personal liability that you might have. Corporate veil protection protects your personal assets from liability that happens within your business. So they kind of work in two different directions. One goes from you down to your business, the other goes from your business up to you. And so what you really want to do is you want to maximize both of these protections. You want both the corporate veil protection so that your personal assets are protected from lawsuits from your tenants, and you want charging order protection to protect the rental properties inside that LLC from your personal liability. And we're going to talk about how we get both of those tonight. Okay. Single member versus multi-member LLCs. Most of you that have had discussions with me have heard this before. And just real quickly, I see Helen Helen, do you have a question? If you can, raise your hand. Oops. Let's see, questions. Oh, okay, I'm just getting through my tools here. Are we supposed to see presentation slides, or is the title slide it? Hopefully, Helen, you are now seeing the slides aren't changing. So none of you are seeing the slides change? Let me look into that. Helen, I'm going to turn on Helen's mic. Unmute Helen. Helen, you're at a computer. Can you speak to me?
We don't have a mic.
I can hear you.
Oh, you can hear us? This is Mark.
Hi, Mark.
Yeah, hi, Jeff. We just have seen the advanced asset protection slide and nothing else.
Nothing else.
Except you're off to the side moving around.
Can you see it on my desktop now with me moving around?
No. No.
Oh, I didn't.
Oh, that did something.
That did it.
Okay. That did it.
Whoops.
Fantastic.
Okay. I'm going to quickly go through these pictures one more time for you. All right. Okay, I've muted everybody. Everyone that's in attendance will get the PDF document of the whole PowerPoint. So you'll get a copy of all of this. Here's the background on me. There's me. There's me. There's my office. There's the legal disclaimer. There's those initial issues we talked about, that there's nothing bulletproof, different liabilities require different solutions, etc. There is the slide on personal versus professional liability. So you can see personal in the little car getting into a car accident, and professional is the slip and fall. Here is the LLC charging order and the corporate veil protection. So again, this charging order protection protects your business assets from personal liability, and the corporate veil protection protects your personal assets from professional liability. And now we are back up to the single member versus multi-member LLCs. Okay, sorry about that, guys. You were just looking at my pretty face, which is probably not what you really wanted to see tonight. Okay, single member versus multi-member LLCs. This is how you get charging order. Single member LLCs in the state of Utah do not get charging order protection. And here's why. Charging order protection comes from partnership law, and it's been around for almost 100 years. And it's a legal theory in equity to make things fair. Let's say you have two partners, partner A and partner B. Partner A is the good partner. He does everything right, doesn't get into trouble, doesn't get into debts. And then partner B is the bad partner. He's got a gambling problem, a drinking problem, and he runs up lots of debts. And suddenly he's got courts and people suing him for all kinds of money. Well, partner A and B in their partnership have this great big apartment complex that's worth $1 million. Partner B's creditors are looking at that and going, ooh, we want that apartment building because we could sell that and cash out and get paid off for all of Partner B's debts. So if the court were to allow the creditors to come in and force the sale of that asset to pay off Partner B's debts, that would hurt Partner A, right? And that's not fair. Partner A didn't do anything wrong. He's honest, he's the good partner, and he should not be harmed simply because his partner is in trouble. So, what the court does is it says, no, we're not going to force the sale of that asset. We're going to keep the asset in that partnership and we're going to keep it protected. All we are going to do is give a charging order to the creditors of Partner B. So what happens is Partner B's creditors step into his shoes, so to speak, and they will get anything Partner B would get through this partnership. Okay. So if the partnership decides to make a distribution, they have profits one year, they want to make distributions. Partner B's profits would go to his creditors. All right. So Partner B doesn't get them. He's the idiot. So his money would go to the creditors, but Partner A's money still goes to Partner A. The thing, though, with this is the partnership can decide not to distribute any money, right? Because the partnership can decide what it does with its own money. The charging order only gives rights to the money, doesn't give them any managerial rights or voting rights or anything like that. They just get whatever Partner B would have gotten in a distribution. So the partnership can decide, you know what, we're not going to make any distributions. We're going to leave the money in the partnership account. And that way, the creditors get nothing. And so the creditors will sit around for years, possibly waiting for a distribution. The partnership could decide to never sell the asset, so it's never going to cash out, and the creditors aren't going to get anything. And what's worse than that for the creditors is that every year, as you know, in and out, you have to do a partnership tax return and issue K-1 statements to all the partners. And if there are profits one year, then that money, even if that money is left in the partnership account, the partners have to pay taxes on it. And so what happens is the tax burden goes to the creditors, and they're going to have to pay taxes on the distributions that they never received because they're still sitting in the partnership account. So a charging order protection is just a great protection for assets in a partnership because no creditor wants to be in that position. They don't want to sit around for years waiting for the cash out while they're continuing to pay taxes on money that they're not getting. But because this sort of derived from partnership law to protect the innocent partner from the bad partner, many states, including Utah, have said if there's no partner, then there's no innocent party to protect, and then there's no reason for a charging order. And in a single and LLCs are considered pretty much under the same rules as partnership law. It's actually part of the same Partnership Act. But because a single member LLC is just one person, there's no innocent partner to protect, and therefore single member LLCs do not get this charging order protection. A multi-member LLC, now you've got partners involved. And so you can have a good partner and a bad partner, and it's the good partner that courts want to protect. And so multi-member LLCs get charging order protections. It's actually written into the state statute that as long as it's not a single member LLC, then you get this great charging order protection for the assets in the LLC, which we all want and love. Now, there's a question about husbands and wives. Is a husband and wife considered a single person or partners? In it's a the true answer to that is we don't really know. Uh, in the state of Utah, the statute does not define a husband and wife as a single member LLC. It doesn't say anything about it. And in Utah, for tax purposes, the IRS considers a husband and wife partners. So any of you that have LLCs and it's you and your spouses are the two members, you should be doing a partnership tax return, issuing K-1s to each the husband and the wife. Um, and you want to be doing that. Not only are you required to do that by the IRS, but what you're doing is you're proving you're creating proof that you are treating this as a true partnership. And if you treat it like a true partnership, then you'll get this charging order protection. There is a case in Florida where I think it was Florida, maybe in Colorado. There's a couple of these cases where a husband and wife were considered a single person, and the court did not provide the charging order protection. In those cases, the facts were very, very different than most of what your situations would be. Um, they were committing fraud and some other things. So I'm not sure the charging order protection would have worked anyways. But for right now, our best guess is yes, a husband and wife will be considered partners and will get the charging order protection, even though we have no case law to support that. Other issues about a single member versus multi-member LLCs. Single member, even though you get no charging order protection, the nice thing is you don't have to file a tax return. Okay, and that will become important later. With a multi-member LLC, yes, you must file a tax return. So again, you get the extra protection, but then you have the extra cost of paying your accountant to do the tax return. The multi-member LLC versus the family limited partnership. I added this slide because when you go to a lot of asset protection seminars, a lot of people push the FLP or family limited partnership, which is a great tool for asset protection. It's been around for almost 100 years in the United States. Um, it does come with a charging order protection because by definition, the partnership must have more than one person. You can't have a partnership with yourself, even though you can have an LLC with just yourself. So by definition, you have partners, so you get that charging order protection, but you only get the corporate veil protection for the limited partners. In a limited partnership, there must be a general partner, and there is no corporate veil protection for that general partner, and that general partner is liable for 100% of the debts and liabilities of the partnership. So when using a family limited partnership, very often we'll create a corporation to be the general partner because corporations will get that corporate veil protection, or or we'll have the family limited partnership own an LLC because the LLC will provide that corporate veil protection. And then the family limited partnership on top of that would provide the charging order protection. And that's great, but then now you've got a little bit more complicated arrangement. And we're going to show that arrangement a little bit later. But that's a very standard way that asset protection attorneys used to set up uh, asset protection plans for their clients, utilizing a corporation as the general partner, and then a family limited partnership that either owned the assets or owned LLCs that then held the assets. The multi-member LLC, on the other hand, gets both corporate veil protection and charging order protection. So it gets both for all members of the LLC. So that's a benefit that it has over the family limited partnership. The reason many asset protections haven't been pushing the multi-member LLC is because it's only been around for 30 years. It's my preference for most clients that the multi-member LLC is generally a better vehicle than the family limited partnership because you can get two protections in one, which means you have less hoops to jump through. And it's the hoop jumping that can really mess you up down the line. Like I said, we can create the most complicated legal structure you want, but if you don't run it correctly, then you've blown all that protection. And so True multi-member LLCs are great. You know, you and a partner, you and siblings, you and your father. These are great. If you're a husband and wife, yes, we still believe you get to charging under protection. If you want a little bit extra, you can add in a corporation as a third member, maybe. You can add in your family trust, that's your estate planning trust, as another member. Or if you're a single person, right, you don't have a spouse and you don't want to partner with somebody else, and so but you want this charging order protection, you can own 90% of the LLC, and then you can set up a corporation that owns 10%. So now you've got a multi-member LLC because corporations are considered separate identifiable entities. And both of these file tax returns. So yeah, there you go. There's the multi-member LLC versus family limited partnership. You're going to see these in different arrangements, but I wanted to kind of highlight what they are and some of the differences between them. Land trust versus family trust versus irrevocable trust. Okay, so trusts are used in conjunction in your asset protection plans. The land trust is specifically for holding title to property for privacy purposes. Now, I'm not a huge proponent of trying to always maintain your privacy, like in situations like that. Now, it's great. I've got clients that do it. There's no problems with it. It totally works. It adds an additional thing to your life. But what happens is we create a trust, and the trust holds title to the property. So the property is titled in the name of the trust, not your LLC. And the reason we've been doing this is because LLCs are recorded with the State Division of Corporations, whereas trusts are not. So because the LLC is registered with the state, people can look it up and see who the members are, at least in the past. Now in the state of Utah, we can create LLCs without listing who the members are. So we can create LLCs that provide privacy at this point, which is a great thing because it kind of lessens the need for the trust. But I still have many clients who use the land trust. And I also use land trusts when your LLC is owning property out of state, and you'll see that a little bit later. But really, that's all the land trust does is hold title. Title is held in the name of the trustee and the trust. So when we record property here in Utah, we record the name of the trustee for the trust. So somebody's name is going to be on the county records. And so when people set up these land trusts for privacy purposes, they would either get a family member, Aunt May, who lives in Alaska, or they'll hire a professional trustee like a bank or a law office to be that trustee so that their name isn't on it. Because it wouldn't make any sense to have you as the trustee of the trust, because now you just put your name on title, and the whole point of using the trust was to keep your name off title. So it can become a little complicated. And then the beneficiary of that trust is your LLC. The land trust does not have any asset protection purposes. So if there's a problem with your renters, they are going to sue the trust, which will then hit the beneficiaries, which is the LLC. So in essence, they will just be suing the LLC, just as if the LLC owned the property itself. A family living trust is for estate planning, estate tax savings, probate avoidance, Medicaid, Medicare maintenance, and things of this nature. All of you should have family living trusts. They're great things to do. We also do wills and trusts at the office. So if you need to discuss your family trust or your will, please let us know. But there's no asset protection in a living trust. If you had all your rental properties in the name of your family trust and you were in a car accident, the court can make you take those assets out of the family trust, sell them to pay off the judgment. And if you had problems with your tenants and the family trust owned the rental, and they sued the family trust, they could go after any other assets in the family trust. So never, never, never title your real estate rental properties in the name of your family trust. If you do, please call the office. We will get it out very, very quickly. Now, an irrevocable trust. Some family trusts can be made irrevocable, and your trust becomes irrevocable upon your death. But until that time, a family living trust is not irrevocable. But the nice thing with an irrevocable trust, and I cannot say that tonight, is it is super asset protection. It is probably the single best asset protection device we have. The problem is it's not usually convenient for most investors because in an irrevocable trust, you, the owner of this asset, put it into the trust, but you're not a beneficiary of the trust. The beneficiary might be your children, a charity, a church. It's somebody other than you. So you've really given away that property and that asset. You can still use it, you can sell it, and then buy something else. But the proceeds, the equity, the money, all of that must stay in that trust because that trust is for the beneficiaries. The money and the assets belong to the beneficiaries, not you anymore. So you cannot sell that and retire. You cannot sell that and go on vacation. You cannot sell that and buy a car or other assets or stocks or bonds or anything else. Because in an irrevocable trust, you've given away the asset to whoever those beneficiaries are. And that's why it's protected, is it's no longer your asset, and so the court can't attach it in a judgment because it no longer belongs to you. And most of these trusts are also written that if the beneficiaries get into trouble, their creditors can't touch it either, at least not until the trust says the asset needs to be distributed. So irrevocable trusts are great asset protection tools, but generally not used for most investors with their real estate properties. Now, if you are older and or maybe you have a home that you know that you're not going to sell, you don't need it as an asset, um, you just want to make sure it's going to be around for children, uh, and you're good with not ever having access to that asset again, you could certainly look into putting that asset or that property into an irrevocable trust. That certainly would work. Okay, S-elected LLC versus S-corp versus C-corp. These are tax shelter entities, not asset protection entities, but they're often used in conjunction in your asset protection plan. So if you have an S-elected LLC, which is essentially an LLC that's taxed like an S corp, or a corporation or a C corporation, you've done this for tax advantages or tax benefits on active income that you are making in your real estate investing. Rental properties are not active income. And so there's no tax benefit to putting a rental property into an S-elected entity. As well as if you do put an asset into an S-elected entity, you really can't transfer it out without there being additional tax burdens. So S-elected entities are not used for holding long-term real estate. So don't ever do that. If you've got an S corp or an S-elected LLC set up that you might be doing your flipping in, or you're wholesaling in, or your hard money loans, or you're a contractor, or you're a real estate agent making commissions, do not put rental properties into that S corp. Okay, but we will show you how these are used within the asset protection. The difference between an S corp and a C corp. For that, go to my website, go to the video education page, and go watch the webinar that I did on C corps versus S corps. C corps do provide some additional tax benefits, but I have yet to have a client where the benefits outweigh the additional possible taxes that you'd have with a C corp. So I very, very rarely set up C corps for clients. And if I do, I have very long conversations with their accountants and with them to make sure that it is actually something that's beneficial. For 99.9% of you, for your active real estate pursuits, such as flipping and real estate commissions and wholesaling, just do an S-elected LLC. That's our recommendation. Okay, here we go. We're going to talk about different structures, uh, actually 12 of them plus two bonus ones, of different ways to hold rental properties. So again, we're not really talking about your flips or your wholesaling because that's you're going to do that through your S corp. This is asset protection. We are protecting our long-term assets like our rental properties from lawsuits and from personal liability. Number one, this is the simple LLC route. This is the basic setup for most beginning investors. This is a tried and true way of holding rental properties the way we've done it for decades. And that is you set up an LLC with one or more members. And again, multi-member LLCs get better protection, that charging order protection. So we always kind of recommend multi-members. But again, it doesn't have to. It can be just you, and you can just rely on that corporate veil protection. And you put your rental property into the LLC, which we're calling My Rental One LLC. Now, if you notice that the house is inside the LLC, that means the LLC holds title. So when you close, and this is one of the reasons why you want a good, know what you're doing and have good escrow officers and title officers that know what real estate investors are doing to make sure that you title these correctly. But you'll title the house in the name of the LLC. Your lease agreements with those tenants will name the LLC as the landlord. Okay, that is also very important. And then, of course, the rent will go into the LLC's bank account. There are other hoops to jump through, but those are some of the biggies. And if you have multi-members in this, then you get both the charging order protection and the corporate veil protection. So this is a great situation. Okay, and very simple. You have one company, one bank account. If you have multiple members, you have one tax return. Very simple and straightforward to use, and generally the recommendation for beginning investors. Now, what happens if you have more than one house? Okay, this is the big question. Well, there's a couple of ways to do it that many of my clients have. And I would say about 50% of my clients use this scenario number two. Call it the Pile 'em In LLC. And that is we just put a number of properties into one LLC. Um, the good side of this is you just have one LLC, one tax return, one bank account, one set of corporate documents, one for meetings and all the hoop jumping. You just have one company. So from a bookkeeping and managerial standpoint, it's very easy and straightforward. If you have multi-members, you get both that charging order protection and the corporate veil protection, so that's great. Um, if you get the charging order protection, all of those assets inside are protected from your personal liability. The problem is if you have liability in one of the rentals, with tenants in one of the rentals, then they're going to sue the LLC. And so anything that LLC owns is subject to the lawsuit. Now, your personal assets and other LLCs and other savings accounts and stuff are protected from that charge, from that corporate veil protection, but anything in that LLC is at risk. So you could risk losing those other properties because you have problems with tenants in one of them. Generally, I sort of advise clients that this is a situation where maybe these LLCs are mortgaged, so maybe there's not a lot of equity in any of them, and so even if they were to be sold off, you're not losing a lot of equity. Now you are losing future value because you've lost that rental property, um, and hopefully it was going to go up in value over the next 10 or 20 years, and you would have had a lot of money. But at least at this time, you're not losing any current major value. So I would not put a rental property that is paid for in cash in with a rental property, that is mortgaged, because if anything happens, the one that you own outright is the one that's going to be sold, and you're going to lose it. So again, the benefit is that it's convenient and easier to use and maintain. The downside is that all of the properties are at risk. Number three, the Lots of Work LLCs. This is essentially, and I've got a few clients who do this. This is that they just put every rental property into a separate LLC. Now, if you're a single person or you just have one member, then this is totally fine. Because each of these LLCs as single member LLCs will not file a tax return, so you don't have to worry about lots and lots of tax returns. You will need multiple bank accounts, um, and the liability is separated one from the other of the properties. So if you got sued in rental number one, rental number two and rental number three are still protected. Now, if you have multiple members, this is not a good arrangement because if you had two members of each LLC, then each LLC is also filing a tax return. And so suddenly you're filing a lot of tax returns on top of having lots of different bank accounts and lots of different corporate records. So what we do in that situation is this. It's called the holding company LLC. And what we do is we create a holding company, which is multi-member. And we'll have husband, wife, maybe their family trust, maybe a corporation, maybe a family limited partnership or something else kind of in there. So we have a true multi-member LLC that gets that charging order protection. And then that LLC owns 100% of each of the rental 1, 2, and 3 LLCs. So what does this do? Each of those rental LLCs, because they're single member, don't file a tax return, so that's good. The only tax return is for the multi-member holding company. The liability is separated out, one house from the other, so that's good. Each of those rental LLCs, it gets that corporate veil protection, which protects the others. And because of that multi-member holding company, you get the charging order protection from personal liability. So this is a great way to do it. Very often, you'll also see kind of a variation of this. Instead of having a holding company own each one of these LLCs, they'll have a family limited partnership or FLP be the owner. In fact, that's kind of the historical way to do it. Before we, I got probably just as old timers and old attorneys that kind of grew up in the days of family limited partnerships, they would have set up family limited partnership that owned all of the LLCs that own the rental property. But again, I generally recommend LLCs over the family limited partnership, but we can certainly discuss both with you. Boom. Now here's one that is newer that I get a lot of questions on. It's the series LLC. What a series LLC does is it mimics this arrangement in one LLC. So what you have is you have an LLC that's defined by state, and you have to have the right kind of articles of organization, and you have to have the right kind of operating agreement. It is a different kind of LLC than a regular old LLC, so it must be filed differently or amended. But what it does is it sets up one LLC that is authorized to create sub-series within it. And each one of these series within it has separate liability one from the other. So it mimics this arrangement where this LLC is separate from this one, is separate from this one. But of course, in this situation, you have 1, 2, 3, 4 LLCs that you have to pay a lawyer to set up. And then you have 4 bank accounts and possibly many tax returns. This is one LLC, and each of these series will hold title and separate out the liability. So it's a much more efficient way to hold multiple assets in one company, and it was created specifically for this purpose. People were complaining that if they had lots of assets, they wanted to separate out, that they were kind of tired of setting up lots and lots of LLCs. And so a few states, and about 9 states now, allow the series LLC. So they're not valid in all states yet. It's been around in Utah for about 8, 9 years. Utah was one of the first. It is set up by state statute, and the statute says that each one of these series get separate liability, which is great. Um, and so it's just a more convenient way to hold lots of properties. And after the number of years kind of that have been around, we're getting more and more comfortable with it. I'm comfortable with it. Um, Learning how to run a series LLC is slightly more complicated than a regular old LLC, but certainly with our help and instruction, you can do it. Notice this box. This box is essentially that holds this house. This is how you're going to title it. Okay, again, good escrow title officer, and I know a lot of title officers who don't know how to do this. To title this house and to keep the separate liability, it must be titled in the name of the series. And so what that full name is House 1, that's the name of the series, a series of My Series LLC. So this is the name of the LLC right here. And then House 1 is the name of the series. And so title must show this exactly. You do not record in the name of just the LLC. Uh, and then there's some bookkeeping and accounting, and we can kind of work with you on how to do the bookkeeping and accounting. But this is a great tool for real estate investors and my clients who are building a large portfolio of rental properties and don't want to spend a lot of money on legal fees and bookkeeping time and expense. So very, very fond of the Series LLC now, and we can certainly talk to you more about that. Okay, Land Trust LLC. This is essentially utilizing the land trust for privacy. We talked a little bit about privacy earlier. As long as you get somebody to be that trustee, and my office can certainly do that for you, and we do that for a lot of our clients. You can title the house in the name of the trust, which is a private document, so nobody knows. You make your LLC the beneficiary of that trust, and of course you have your members that own this LLC. Again, this is kind of came around about 10 or 12 years ago. A lot of the real estate investing bigwigs and gurus were using this trust situation because LLCs were recorded with the state and they didn't want to have, people knowing their business. So they kind of titled everything in the name of trusts. These days, again, with LLCs that we can keep more and more private, we can sort of accomplish the same purpose. But if you do want to use trust, this is the way to do it. Again, title is here. So the house is titled in the trust. The beneficiary of the trust is the LLC. This LLC gives you the corporate veil and charging order protection from lawsuits. Okay. Oh, going back here. Remember that if you do this and you are the trustee, remember you've got a lot of different hats to wear. You're the trustee of the trust. Your LLC is the beneficiary. You might be the member of the trust or the LLC, and you might also be the manager of the LLC. So you have a member hat, a manager hat, and a trustee hat. And you kind of have to remember which hat you're wearing at which time. Okay. Question. I got a question here. Most people buy rentals in their name and then transfer to the LLC. Transferring rental can void title policy if you do not get the special policy or the name change rider. That is true. Different title companies have different perspectives on this. There was a little scuttlebutt recently that transferring it into the name of the LLC would void it. I've talked with attorneys for underwriters. It's not as scary as it was kind of being made out to sound. It's been done for decades. The attorneys are like, oh, well, if you're sued and it was in the name of the LLC, and the underwriter says they're not going to insure the LLC, then the attorney said just transfer title back into your personal name, and they would cover it that way. But you should absolutely find a good title and escrow officer who understands what you are doing and make sure you have the correct title policy that covers your LLC. Also, with that question, uh, most people buy rentals in their name and then transfer to LLC. That is correct when you are getting traditional financing, because a commercial bank will require that your name be on title when they give the loan. Um, and there are actually some issues with the due on sale clause and transferring to the LLC. That is another seminar that I'll be doing over the summer. But if you're buying rentals, there's a number of ways to actually never put your personal name on title. You can buy in an LLC, do the rehab, and then go to refi. And there are banks that will refi your property in the name of the LLC, believe it or not. So you don't have to take it back out into your personal name. But great comment there about title policy and closing and transferring title into the name of the LLC. Make sure that you work with a title company that understands what you're doing and you get the correct policy to make sure you are covered. Great, thanks for that question. Okay, this is a land trust. I'm going to really quickly make sure no one's hand is raised. Okay. Using the land trust and the series. This is just a combination of using a series LLC for separation of liability and the land trust for anonymity or privacy. Again, the way you do it this way is just remember that in this house number one trust, the beneficiary will be this series. So the full name of the series, not the name of the LLC. Okay, because if you make the beneficiary the name of the LLC, then the liability would go to the whole LLC, which would encompass all of it. So again, just you got to make sure that your paperwork and your documents are done correctly. House titled in the name of the trust. Beneficiary of the trust is the name of the series. Okay. Next one. The other state LLC. These days, I really only do trusts for most clients now when they're holding properties out of state, particularly in California or in states that don't recognize series LLCs. Here's what happens if you own a property outside the state of Utah and you have a Utah LLC. Kind of depends. The old way we used to do it would be just to register your LLC in the other state, and then you would get kind of the protection. Now, do you need to register that LLC in the other state? Yes, you do if your LLC conducts business there. So it comes down to what are you doing with that rental property, let's say in Arizona? Does your LLC just own it and that's it, or does it also manage it? If you're managing it and your LLC is the landlord and you're managing the property yourself, like you do here in Utah, then you would have to register your LLC in that state because you're doing business in that state, which means filing an application, getting a registered agent in that state, which costs you money each year, and then there's usually a renewal fee for that every year. So it will cost you a little bit of money to register your LLC in another state. If you're not doing business in that state, which is generally most clients, because most clients don't manage properties out of state, it would be just too hard, so they have a property manager do it. Then you can either just put title into the LLC, or more commonly, put title into the name of a trust and make the beneficiary of that your LLC. That way, it's clear that you do not need to register your LLC in that state because the LLC doesn't own the property. The trust owns the property, and trusts are not recorded with the state. And so as long as you put that out-of-state property in the name of a trust, you don't have to worry about registering it in that state and paying the filing fees and the registered agent fees. So these days, that's kind of what we do with out-of-state properties. Title them in the name of the trust, name the beneficiary, either the series, or if you don't have a series LLC, the name of the LLC, and keep it that way. Okay. There was something else that I was going to say about that, but hopefully will come to me. The Property Management LLC. Now, I've used this arrangement with a series, with a trust, and the property management company. For my clients with a lot of rental properties, this is my preferred arrangement. Probably without the trust, but definitely with the property management company. Here's why. If you're using a series LLC, or you're using multiple LLCs for each property, um, you've got a lot of bookkeeping and banking to do because every series must be accounted for separately from the other. So let's say in series one, in this house one is making you a lot of money. It's flowing positive, $800 a month. So this is your cash cow. So it's lots of money going into this account. House number two isn't flowing positive very well, maybe only 50 bucks a month. And so what happens is very little money goes into this account for series two. But there's money sitting in the account. And so you're thinking, well, I've got all this money in the account, but that money really belongs to house one. Okay. And you cannot use the money from house one to pay for, let's say, a repair on house two, because then you're commingling funds in between the series and you'll lose the separation of liability. And so it becomes, and then you've got lease agreements for house one, lease agreements for house two, lease agreements for house three. And the landlord on each of those leases will be the name of series one, series two, series three. And so it can become very confusing, very time consuming, and just a lot of paperwork and remembering which house is in which series or which LLC. And so what we do is we create a property management company. This is probably going to be an S-elected LLC. It's going to be its own separate business, just like you would hire a third-party property manager. All the leases are in the name of the property management company. So you don't have to worry about putting a lease in series one, a lease in series two, a lease in series three, and having your tenants pay to different accounts. All the leases are in one name. There's one bank account because the property management collects all these rents. The property management can pay all the utility bills, all the handyman bills. It can pay the mortgages. And so all the accounting all goes within one company. So it really lessens the bookkeeping over on this side of things. And the second thing it does is it deflects some liability um, to the property management company. So if, let's say, you have problems with house one and a tenant sues you, and it's because the stair railing wasn't repaired fast enough. They called the property management company. They said the railing was broken, and it took a week to get out there and fix it. And during that week, somebody fell down the stairs and broke their neck. Of course, the tenants are going to try and sue everybody. They're going to sue the LLC, of course. And what you're going to do as the owner of the LLC is say, hey, it was the property management company that was responsible for making that repair. They are the ones that are liable, so they have to pay the judgment. And the court, if the court agrees, and the court will say, great, property management company has the liability. They were supposed to make the repair. They didn't. What assets does the property management company have? Well, guess what? The property management company doesn't own any assets, right? It's just a property management company. And so it doesn't matter that it's being sued. It has nothing to sell off. So it's a great way to make your life a little easier. And it's a great way to deflect liability onto an entity that has no assets. Um, so really like that for my clients with lots of rental properties. I would not suggest this for a new real estate investor who has one or two homes. It's just probably not worth it at that point. But it's certainly something you want to think about as you grow your business and you build your portfolio of doors. Okay. Number 10, this is the family limited partnership use with the LLC. This is kind of the way that asset protection attorneys set up asset protection plans for the last probably 30 or 40 years. What happens is you have your family limited partnership. You've got limited partners in here, okay? Husband, wife, son, daughter, son, okay? So they're all limited partners. You have a general partner. Somebody has to be the general partner. It can be a corporation, which provides some uh, corporate veil protection. So we generally recommend that. But if you're using, if all of your assets, okay, are in an LLC, whether it's a series or not, but if all of the rental properties are here in this LLC, this LLC comes with corporate veil protection. So the family limited partnership really wouldn't have any liability because it all stops right here with this. Hopefully you can see my cursor because that's what I'm using to kind of show things on the screen. Um, so you could have, maybe the husband be the general partner. And as long as this family limited partnership doesn't do anything itself to have liability, then I'm okay with that. So as long as we use an LLC to actually hold the properties, and then the family limited partnership owns 100% of the LLC. So the LLC is a single member LLC, which is fine because it won't do a tax return as a single member LLC. It gets the corporate veil protection to protect the family limited partnership. And then the family limited partnership provides the charging order protection from the personal liability of everybody else. So this is a great and very solid asset protection tool. It's a great setup, super protective, really like it. The one downside is, yes, it's a bit more complicated, right? You got an entity in the LLC, you've got an entity with your family limited partnership, and you may have a corporation involved. So you've got lots of hoop jumping to kind of do. The family limited partnership will do a tax return. The corporation will probably do a tax return if you use that. And any money, this is something that a lot of my clients had other attorneys set this up for them, didn't really understand. It was a husband and wife, right? They're the real investors. And they put their kids on the family limited partnership, which is a good thing. The more the merrier. I always say that, the more the merrier. And so their rental properties were making money. And so either they were taking money from the LLC that owned the rental properties and putting that directly into their personal bank accounts. So they skipped over the FLP. That is a no-no. That is commingling funds. That is bad because the owner of that LLC is the partnership. So the money from the LLC has to go to its owner, which is the partnership. And then when money comes out of the partnership, it has to go to all partners in proportion to their interests. So that means that some of that money had to go to the children in their 1% or 2% interest, whatever they happen to have. But the parents weren't giving the kids any of the money. So essentially, the parents were stealing from the kids. And that is true. It doesn't matter that you're all in the same family. It doesn't matter that mom and dad are really the investors doing all the work. Once you name those kids as part of that family limited partnership, they have rights. They have rights to that money. And in fact, they'll pay taxes on it because if you get a good accountant who knows what he or she is doing, that accountant is going to issue a K-1 statement to the children showing that they received some of the money and they're going to pay taxes on it. So again, this is a great protective tool, just a little more complicated. And but again, we can always help you through the complications. Okay, number 11, the corporate LLC. This is used if there's a if there's a single person who is not married and doesn't want a partner on their deals, but they want that charge order protection. So if they own the LLC just by themselves, they wouldn't get it. So what they can do is they can become the one member at maybe 90%. Then they can set up a corporation that owns 10% of that LLC, which makes it a multi-member LLC. So it's a great way for a single person to get charging order protection. And I have some married couples who will throw that in just for the extra confidence in the event that a husband and wife are considered a single member. Don't think that's going to be the case. Hope that's not the case. But again, until some court actually looks at that and makes a decision, we just don't know. So this is kind of an extra protection by adding in this corporation which is a separate identity under the law, and make that the other partner. Oh, the whole enchilada. Um, this is a property management company doing all the work. It has all the leases. It collects all the rents. You're using trusts for privacy or anonymity. You're using a series LLC to separate out liability. You've got your members, and you've got a corporation, again, as a solid other member of that series LLC. Um, Great, but again, can be super complicated, and just got to know what you're doing there. The maybe S corp LLC, and this is kind of extra. So these. Oops, let's go back. The 12 that we just did are probably account for 99% of the asset protection plans that I set up for my clients, big and small. There are a few clients that um, do a lot of different things in real estate. So far, we've been talking about asset protection and with rental properties, long-term holds, right? We're not talking about the S-elected entities for tax savings. But a lot of my clients actually have those S-elected entities already because they're also doing flipping. They're also doing wholesaling. They might also be real estate agents earning a commission. They might also be contractors with a contracting business. And so this is kind of for them where they have their S Corp. If they have lots of different revenues that are considered active income, it could be that they're big flippers. It could be that they have a property management company. It could be that they have a real estate agency company or a contractor, right? And especially with like businesses that run a lot of liability, such as a general contractor. Uh, General contractors, I wouldn't run my flips through the same company that I do my contracting in, because if I'm ever sued as a contractor, they can go after any flip projects that I've got going on because they're owned by the same company. So what we do, and of course, if you set up a flip company that is S-elected, and a property management or real estate or a contracting business that is S-elected, both of those have to do tax returns. And suddenly they're doing a lot of tax returns and they don't want to do that. So we'll set up an S-elected holding company, and that one is S-elected. That will file a tax return, and it owns 100% of the other LLCs. So these LLCs are now single member. They do not file a tax return, but they conduct business all on their own. So they separate out the liability of the flips from the management, from the contracting, from the real estate commissions, etc. So this is kind of for clients that have a complicated active income in real estate investment. And then what we'll do is we'll make this holding company either the general partner of the family limited partnership or just another member of the LLC. Now, as a side note here, let's say I didn't have lots of other businesses. I just had my S elected LLC that I do my flipping in. So I have my flipping company and I have my hold company, which is a very common thing for most of my clients. You would not make this flipping company a member of your LLC that holds properties for this extra member. Why? Because flipping does incur liabilities. And if something happens on your flip project and your flipping company is sued, that company then owns part of these assets. So again, these are just variations that may apply to some of you. If they don't, that's great too. But I'm just giving you options so that you're more aware. Again, whenever I sit down with clients and discuss their asset protection, we do it customized. And the final one we're going to talk about is called the Family Living Trust LLC. Now, we talked earlier that the Family Living Trust is for estate planning purposes. A lot of you have them. You should all have them. If you don't already, you should get one. Even if at this point you don't incorporate it into your asset protection tools, at least you have it, and it can hold on to other assets such as savings accounts, life insurance policies, stocks and bonds, because those things don't have any liability. You're not going to get sued from owning a stock. And then if something were to happen to you, that family living trust can allocate all the assets, all those other assets without probate. Um, and you can incorporate that family trust into your asset protection by making it a member of your LLC. Now, this LLC itself will have to go through probate because some of it is owned by the members as individuals. And remember, the family living trust is designed to avoid probate, but it can only avoid probate on the assets that it owns. So if it doesn't own the asset, then it's outside of the trust, and anything outside of the trust has to be probated. So part of this LLC would have to be probated, um, but you still have accomplished the purpose of the family trust controlling most of it and controlling all of your possible other assets other than real estate. So that is another option. We're going to quickly finish up with a few things. Just my thoughts on privacy. Uh, I think privacy is a little overrated. I just don't think you can really keep yourself private anymore. I can probably find you. Maybe an incompetent lawyer that's trying to sue you may not find you, but I could, because I kind of do this every day. But we're just so out there now on the internet. And some like big real estate investors that some of you may know that teach classes, teach seminars, have websites, and even some of you may have websites where you have your rental properties or your company that you do flips through or something like that. So people are going to know what you do. They're probably going to know that you're in real estate somehow. And it's a pretty logical assumption that you probably own rental properties. Now, can they confirm that if you stay private? No, they can't confirm it. Um, so there is that benefit, and I can tell you that probably the biggest benefit to privacy is honestly having a lawyer. I'm not just making a plug for my services, but I get a call probably once a month from somebody else looking for information on one of my clients' companies. I'm their registered agent. They're a private LLC, so their names are not listed on the state website. That LLC might own the property, and that's how the attorney found out about the LLC. And they found the registered agent. That was me. They called me up and they say, "Hey, we know that this LLC owns this property. Who are the owners?" And you know what I tell them? I say, "I'm sorry. I am bound by confidentiality. I cannot disclose any information about the company without a court order." And almost invariably, I never hear back from the lawyers again. And that actually has happened. I've had lawyers call up asking for the members. I've had lawyers call and ask for the insurance policy uh, on the house. And I said, "I'm sorry, I can't give out any information about the LLC or its insurance without a court order." And I never hear from them again. So it is great, privacy. You can, the trust will do that. What if someone's looking for you? They're gonna go after the trustee. So if you've named your Aunt Mabel, who lives in, Mapleton, as the trustee, attorneys are going to be calling her. So she's going to get inundated with the phone calls from the attorneys asking for information, and she may not be strong enough to withstand their threats. When lawyers call, people seem to just start giving information. They think they have to, and you don't. um, so kind of just be aware of that if you're using trusts or privacy. If you're concerned about privacy and you want that, just feel free to call the office and discuss it with us, because we're happy to talk to you about that. Corporate governance. um, this is the final prong of asset protection. There's sort of three sides of a triangle. One is the legal structure, the other is privacy, and the third is corporate governance. And we kind of started off talking about that earlier, in that I can set up any legal structure you want. If you don't maintain it correctly, then you're really not getting any protection. If you don't do your contracts correctly, if you don't do the bookkeeping correctly and the accounting, if you commingle funds, you rob from Peter to pay Paul sort of thing. These things can lose that protection. In fact, that's how most people lose their protection, particularly in commingling funds. That's the big one. And the second is not having the proper documentation. They'll set up an LLC. They'll even transfer title into the name of the LLC, but then they'll go and do all their lease agreements, and they'll put their personal name down as the landlord. Well, you just made yourself the landlord, which means you're now personally liable. So again, and these are the kind of things that we help our clients with, and some of the things that I teach. And I will be doing a corporate governance class over the summer, probably a webinar, a 1-hour webinar. So kind of be looking out for that. And I'll teach you, I actually have a list of 41 things that you need to be aware of with corporate governance. So we'll go over that. Oh, I have a few of them here. Didn't realize that. How many do I have? Got a few of them. Okay. Some big things about corporate governance, and we've got a few minutes, so I will go on with this. First thing to remember, business equals business, personal equals personal, and never the two shall meet, okay? Just learn it, live it. This is gospel. Business expenses get paid out of the business account. Personal expenses get paid out of your personal account, period. Period. Don't ever pay personal expenses out of the business or vice versa. And it can get a little confusing. For example, a cell phone. A cell phone is a legitimate business expense, right? Most of you probably write off your cell phone bill. But the cell phone bill, if you look on that bill that you get from AT&T or Verizon, is going to list your personal name, right? The account, your cell phone account is going to be in your personal name, which means that is a personal debt. And that means that personal debt must be paid from personal funds, not business. Okay? Hope I made that clear. But the next step is, if it's a legitimate business expense, how do you write it off? It's very easy. And I've been doing this for years. Take your whatever bills you get in your personal name that are legitimate business expenses, pay them out of your personal account, and then get reimbursed from the company. You can just sign it, just get a sheet of paper out, write the name of the bill, the amount, sign it, submit it to yourself, sign it as accepting it, and then the company, the business checking account, can pay you, reimbursing you for your expenses. That's how you do that. There's a couple of there's one exception to that, one big exception, and that is mortgage payments and escrow, taxes, insurance that are escrowed in. Your mortgage is a personal debt, right? Your mortgage is in the personal name. No bank is going to give a loan in the name of your LLC. So that is a personal debt. However, that mortgage, not only is it have a lien on the property, it's so intimately tied to the property, as is property taxes and your property insurance, that I'm comfortable with the business account paying your mortgage and escrow. Because it's really hard to kind of make the claim that the business paying that mortgage was paying you personally, because it is just so tied to the real estate. That's really the only exception to the business equals business, personal equals personal rule, is just the mortgage payment. And you can pay that out of the business account, and even better yet, use a property management company in the scenarios that I showed you earlier, and just order the property management company to pay it, which is another way to do it. So that's number one biggie. The second biggie is arm's length transactions. If you as an individual ever do business with the LLC, perhaps a loan, or if you use the property management scenario, then essentially your property management company is going to go under a property management agreement with your LLC. Anytime that you do business with your company, or between one company you own and another company you own, arm's length transactions. Okay, That means market terms, market rates, as if you were hiring somebody that isn't you. So if you do a property management agreement between your property management company and your LLC, then your LLC must pay that property management company a property management fee, of 8 to 10%, because that's what it would be in the open market. Make sure that that is in writing. Okay, so just make sure that you treat your businesses like any other business, even though it's just you and you're on one side of the transaction and on the other side of the transactions. Remember that you're wearing two different hats and act accordingly. It's really, if you can understand that you'll solve a lot of problems, because you'll know that you're treating your business like a real business. You're not treating it like it's just you and you can do whatever you want with it. Okay, so treat your business like a business by wearing the right hat. Just remember who you are and act accordingly. I think I heard that somewhere. Um, um, are you the manager of the LLC? Are you the trustee of the trust? Are you the manager of your property management company, which means you're just a property manager? Who are you? And make sure you wear the right hat. And when you're signing, sign in that capacity. And we can certainly help you with that. Here are a few other things that I'll discuss probably in July. I think I'll do my corporate governance webinar. Make sure your LLC has the proper structure, you have the right documents, that it's properly funded, accounting and bookkeeping, that you have meetings, minutes, and keep records, proper contracting. That means putting the right name as the landlord on your lease agreements, and then signing that lease agreement as the manager of the LLC. Okay, and that looks like it. We'll go back to the beginning while we finish up. So thanks for attending tonight. We finished up a little bit early, so about an hour and a half. So that's great. I will now take questions from you if you have any. I'm going to go to, so you can raise your hand. Looks like Tammy Nelson has a question. Okay, Tammy, I don't know how long your hand was up, but I have now unmuted you. So if you have a microphone, you can ask me your question. Can you hear me, Tammy?
Can you hear me?
Now I can.
Can you tell me if in this scenario where you put the management company to manage for the LC,
Uh-huh.
if you're getting a renter's policy, would you put the renter's policy as the lost payee as the real estate holding company, or the operating management company?
It'll be the operating manager. You could actually do both. And I run that by your insurance agent, and make sure you have a good insurance agent who knows real estate investment. But the main insurance I would want on my property management company, because I want my property management company to accept all the liability.
Okay.
And you can do that with your agreement between the property management company and the LLC, essentially your property management agreement, where the property management company assumes the liability. So your property
Okay.
management company definitely wants the insurance.
Okay.
But if it's affordable, there's nothing wrong with another extra layer of having a landlord's policy on your LLC. It can
Oh
get
yeah, I'm talking about
Oh, go
the
ahead.
lost payee of my renter's insurance, the lost payee to have which company? You're saying to have the management company as the lost payee on a renter's policy?
When you require that your renters have a renter's policy.
Right. Yep.
Yeah, on that one, no, I would probably have them name the LLC.
The real estate holding company.
Yeah, the holding company, because that
Okay.
that suit's going to come not from somebody like falling down the stairs and suing for the railing. That's probably going to come from a fire, or something like a water damage or something like that. Um, and at that point, the property management company wouldn't be responsible. It would be the homeowner's insurance.
Okay.
So yeah,
Thank you. I appreciate
yep,
it.
yep. That's that question. Okay. I'm going to mute you again, Tammy. Sorry about that.
Okay.
Okay, let's see. Question. Anyone else with questions? Did I do that great a job of explaining everything? Boy. While you're either thinking about questions, I will let you know that tomorrow I will have Nicole, who's my new admin. So if anyone who had either met or spoken with Mandy, um, uh, Mandy is no longer with me, and now Nicole is my admin. She's awesome. She's got a lot of real estate experience. Used to be a real estate agent, and she used to be an admin for a broker. So she's super knowledgeable. I will have her send out the PowerPoint presentation to all the attendees. So you will get a copy of the PowerPoint tomorrow. Um, Remember the class next Saturday. Make sure you sign up for that. That'll be great. And it is a huge class, and I will be sending out the PowerPoint for that in advance of the class. So don't wait until the last minute, because you'll probably want the PowerPoint before you even show up, because that'll help prepare you for questions, etc. So I'll probably do that early. Okay. Any other questions? If there's no other questions, then I will probably then just say thank you very much for attending. Always remember, if you do have questions, certainly send me an email or give the office a call. We're always here to help you and answer questions. The email is jeff@brailiolaw.com. The phone number is 801-560-2180. So just give us a call and let us know how we can help. And we look forward to work with you. Have a great evening. Remember the class next Saturday, the 17th, and the next webinar in June on better landlording from a legal perspective. So those are the next things coming up, and that one is free. So have a great night, and hopefully we'll talk soon. Goodbye.